working. So to begin with, I am Sabina. I will be moderating this session. I'm a qualified lawyer from the United Kingdom, and I specialize in dispute resolution and commercial contracts. My speakers on the panel today are Tatvik, who is, she's PhD director of the Resolve Academy and an independent arbitrator. She's the deputy chair of the Arbitration and ADR Committee and Commission of ICC Armenia, CI Arb associate member, and board of advisors of Visa Ards. And then we have Perry, who is an Armenian lawyer who specializes in international dispute resolution. Her legal practice is primarily focused on handling cases related to investor state and international commercial arbitration. And currently she plays an active role in the international arbitration team of the offices of the Representative on International Legal Matters, Government of Armenia, representing the state's interests in disputes involving investors and commercial matters. Additionally, Perry also serves as Armenia's representative to the UNCITRAL working groups 2 and 3. So with that introduction done and out of the way, I'm going to now dive into the session. And firstly, the topic is a very, very important one that relates to mooting, as you are well aware, and it's very beneficial for young advocates and students to participate. So we have a number of questions that we're going to address, and we'll keep. If you have any questions, please do feel free to pop them into the chat as the sessions are going ahead, and we'll be happy to address them all at the end. It's just we're going to try not to have any interruptions as the flow of the sessions are proceeding. So to begin with, firstly, if I can start with Tatvik. With regards to the Vis Moot, can you tell me how you believe crafting a compelling legal argument is, how you would go about crafting a compelling legal argument, I should say?
Yeah. Good evening to everyone. Thank you very much, Sabina, for this event and for the kind introduction. So if I try to just be in short with the question that you addressed, like crafting compelling legal argument is not merely a skill, but an art form that requires a deep understanding of the law, mastery on rhetoric, strategic thinking. So first and foremost, you students and young practitioners should understand the preferences, biases, and expertise of the arbitrators. They should tailor their arguments accordingly to resonate with their sensibilities and expectations. A well-crafted argument should speak directly to the concerns and interests of the decision makers to the arbitral tribunal. So I should give like several tips for like crafting compelling legal arguments. First and foremost, they should build trust and credibility by demonstrating a thorough understanding of the relevant legal principles, precedents, and factual context. Their arguments should be grounded in solid legal reasoning and supported by authoritative sources, like organize their argument in a clear and logical manner, start with a concise statement of the legal issue and their position, followed by a systematic presentation of supporting arguments and evidence. Meanwhile, using headings, subheadings, and transitions to guide the readers through their analysis. Persuasive technique is very, very important here, like employing rhetorical devices such as analogy, metaphor, and persuasive language to make their arguments more compelling. Like they should appeal to emotions when appropriate, but always maintaining a professional and respectful tone. So I think my colleague will add some more points to this. From my part, these like viewpoints are important.
Thank you,
Yeah.
Tajvik. That's very, very helpful. Thank you. And again, the session is to do with exploring the art of persuasion, unraveling the intricacies of oral advocacy in the Vis Willem C. Vis International Commercial Arbitration Moot Court. And in this session today, for those that are joining and may have missed the introduction, this is in relation to moot competitions where you have the experience of taking part in this invaluable competition. Now I'm going to ask the same question to my dear Perry in relation to crafting compelling legal arguments and exploring the art of crafting persuasive legal arguments that resonate with judges and arbitrators. So if you can give me your perspective, I'd be most grateful.
Thank you very much, Sabina. Of course, it would be my pleasure. So I would mention firstly the clarity and structure of the arguments. So students should present their arguments in a very clear manner. They should use a structured approach with a roadmap to guide the arbitrators through to their reasoning. So in real life arbitration proceedings, practitioners usually use slides to outline the structure and enhance clarity. However, in the moot court, this visual aid is unavailable, so students should be extra prepared. So moreover, the structure constitutes the opening statement, setting the tone for the speech and further arguments, creating the first impression. So this is really, really important. Secondly, credible sources and jurisprudence. So students should support their arguments with authoritative legal sources, statutes, case law, and relevant precedents. They should show that the legal analysis is supported by sound legal authorities. However, be cautious about relying on outdated cases as they may have lost relevance, and ensure a thorough understanding of the cases and be ready to delve into the specifics, highlight the similarities and differences from the moot court case when responding to questions from the arbitrators. Thirdly, you should address counter arguments. So as in the moot court, the students play both claimant and respondent. They can anticipate opposing arguments even during their preparations and address them proactively during the oral rounds. They should also be able to acknowledge weaknesses in their case and provide reasoned responses to potential challenges raised by the opposing counsel. And my general advice would be that they choose the words and phrases that are precise, impactful, and persuasive, and deliver their arguments with confidence and professionalism, maintaining eye contact. Yeah, that would these are my tips. Thank you.
Amazing advice. So in a nutshell, you both agree that the advice you'd probably give to students is to understand the problem, the facts and the issues, and then the relevant laws in line with that, and identify the core arguments and the legal analysis to support that argument and to understand the legal principles. And so the student should start with an introduction, a statement of facts, the legal analysis, the party arguments, and then finish with a conclusion. And within the moot scenario, they may be asked to draft pleadings or written submissions in respect of the arguments as well, and give some oral advocacy, which would be a detailed argument, and be you should also be ready to address any questions that the judges may raise, and have your legal knowledge very intact, and use effective communication. So everything that you both said, I totally agree. And with that, we'll move on to the next question. So the next question I have for you is with regards to navigating complex cases and scenarios and developing strategies to effectively address them. So Tatvik, if I can please start with you again, and if you can give your detailed reasoning as to why this is so important.
Yeah, surely. Well, it is a hallmark actually of the Wismut competition generally, and where participants are challenged with intricate legal issues and diverse jurisdictional considerations. So though I will give like several points, beginning like by conducting a comprehensive analysis, as my colleague and you, Sabina, mentioned also, of the case materials, like including the moot problem, relevant statutes, treaties, and case law. They should break down the facts and legal issues into manageable components to gain a deep understanding on the case complexities. They should identify the central legal issues at stake in the case scenario, prioritizing them based on their significance and relevance to the moot problem. And of course, they should consider the legal principles, doctrines, and theories that apply to each issue. So recognizing the potential jurisdictional variations and conflicts inherent in international arbitration, and they should evaluate the applicable law first and foremost, choice of law clauses, and procedural rules governing the arbitration process. Like for this upcoming Vis Moot, we have the governing laws of ICC rules. So they should be prepared, like mootists should be prepared to navigate these complexities when formulating their arguments. And also they should craft a strategic approach to addressing the complex case scenario, determining the most persuasive argument and legal theories to advance their position. So these are mainly from my side, the tips, like when we want to navigate through case scenarios, complex case scenarios.
Amazing. And if I can just ask you to expand a little bit, would you agree that when they are putting the strategies together, it can be quite a stressful situation, particularly if you're new to mooting? So would you agree that there should be some strategies and tips for them to overcome anxiety and for example, read the question and think about the issues raised, highlight the facts that are within the submissions, be prepared at the outset, and that would help to reduce anxiety in any stressful situations. You know, do you have any input with regards to that?
Well, first and foremost, students, my advice is to practice a lot, both previous moot and also with their coaches and classmates. Practice is the first and foremost tip in order to overcome all the facts that stressy situations that you mentioned.
Thank you. Amazing. That's wonderful input. Thank you. And Perry, if I can now ask you the same question and you can give me your feedback, please.
The question about nervousness or the
Okay,
initial question you asked. Yeah,
the initial question of navigating
okay.
complex cases, scenarios, and developing
Yeah.
strategies
Well,
to
I
effectively
cannot agree more with that, Avik, actually. I totally concur with her. And it's important to remember that each year the Vis Moot case focuses on a specific subject matter. So it's crucial to thoroughly study this particular field, delve into relevant materials, and even watch videos on YouTube to gain a deeper understanding of the dispute and the disputed domain. So the more familiar you are with the complexities of the case's subject matter, the better equipped you'll be to craft compelling legal arguments and, you know, engage with the arbitrators during the moot court rounds. And also, students should be able to understand the underlying legal principles and how they apply to the facts of the case. So here we have an advantage because the Vis Moot case outlines the specific issues to be argued. So students can identify the complex case scenarios that each issue represents and develop a strategic approach accordingly. And I think to develop a strategic approach, it is important to consider, again, potential arguments, counter arguments, as well as evidence based on the facts of the case. And throughout this process, students should maintain, you know, creativity and critical thinking. And finally, and I think we'll come to this later as well, team collaboration is really important. And Vis Moot is all about the teamwork, discussing different perspectives within the team and finding potential solutions to complex case scenarios.
Thank you, Perry. We are definitely going to touch upon that little topic near the end. So just to sort of wrap up on this question, it's very, very important, as my speakers rightly said, that you highlight the facts and that you refer to them in your submissions, and that it's also very important to spot any red herrings. So there may be some facts that are thrown within there that are not relevant, and it's very important to be sure that you understand the which facts are relevant and which aren't. And it's very important, as rightly my speaker said, to read the case law, to prepare your arguments on what the law says, and have an effective skeleton argument. Don't just use a script on the day. And remember what you are going to say. Have a good structure in place, practice, practice, practice. And again, my speakers have said that so many times, please practice. It's so important. And keep your arguments very, very precise. On the day, don't panic, because although you can't anticipate what questions you may be asked by the judges, or there may be a scenario where the judge might be against you, you've just got to be sure that you control your performance and listen to what the judges say throughout the talk. Ensure you take notes and that you are ready to address any concerns or any arguments or any questions that you're asked on the spot, which is very, very important. So thank you both. I really appreciate your input there. Now, moving on to my next question to you both. This time we'll start with Perry. So we'll mix it up a little bit. With regards to this question's to do with mastering oral advocacy and techniques. So if you can just give me your points on this topic, I'd be really, really grateful.
Yeah, I think to excel in oral advocacy during moot court proceedings, students should focus on mastering several essential techniques. Firstly, they should ensure that arguments, we said this, but yeah, I'll repeat, that the arguments are presented clearly and concisely, avoiding unnecessary, complex language that may confuse the arbitrators. So structure arguments logically with a clear introduction, main points, and conclusion. Because this organization really helps the arbitrators to follow your arguments and understand its progression. Also, I think it's important to be prepared to adapt arguments based on the position of the opposing team, as well as based on the questions received by the arbitrators. And this flexibility and adaptability are key to addressing effectively to unexpected challenges. And as you said, Sabina, students should pay close attention to questions from arbitrators through active listening and respond to them thoughtfully. And again, you should maintain eye contact, speak with, conviction, and engage with the panel by using appropriate gestures and voice tone. Don't be monotone. And at all times, please maintain a professional demeanor, showing respect to arbitrators, but also to opponents.
Very well said. And Tatvik, if you can kindly just elaborate on oral advocacy tips as well, I'd be so grateful.
Yeah, I totally agree with Perry in terms of structured argumentation should be in line during the whole process of moot court, and also like in terms of engaging the panel in the discussion. But I would also add here like effective communication in terms of articulating your arguments clearly and confidently, like using a measured pace and appropriate tone, because we know that rhetoric plays crucial part mainly in oral advocacy, and students should avoid excessive use of legal jargon or complex terminology that may confuse the tribunal, tailor their language to the audience level of understanding. So in order to use persuasive techniques, they should like employ rhetorical devices such as repetitions, analogy, storytelling to make their arguments like more persuasive and memorable, and yeah, surely to apply to the tribunal through eye contact or referring. For example, may I ask the tribunal whether they are with us, or such kind of expressions can be used during the moot court. And also what I noticed from my experience when taking part in different moot courts, both for Vienna or pre-moot court, like I noticed that students are not so confident So confidence is very, very important. Like they should project confidence and poise throughout their oral presentation, even when faced with challenging question or interruptions. Because when we interrupt abruptly the students and ask questions, they are just somehow stuck and they are not able to continue, as if they lose their like place where to continue. So this is
Yes.
very, very important. Like they should maintain good posture, gestures, and facial expressions that convey conviction and credibility.
Yeah.
And also, yeah, Perry has already mentioned listening, active listening. They should be engaged in active listening in order to be able to answer the questions both from tribunal and also from their counterpart. And also here I should add time management, because sometimes in the sessions we notice that students do not manage to uh, express themselves within the given time. So in this regard, they should practice effective time management to ensure that they allocate sufficient time and they manage to render what they want to say within the given time. So these are from my side on the mastering like oral advocacy techniques.
Amazing. I love those tips. They are very, very important. And thank you so much for sharing your knowledge, your experience. I really appreciate it. And also, I would just add in within that if you are asked a question on the spot, you do need to think quickly. And in that regard, it's very important that you know the law that best backs your argument, and always put your argument forward so that the other counsel doesn't catch you out in any way, and make sure that it's backed up so they don't catch you out. And at the same time, as rightly both my speakers said, that you do need to respect courtroom etiquette. Also within that, you may be in a different jurisdiction to where you are used to presenting or where you've trained, and so make sure that you research the jurisdictional issues. It may be different due to the size of or the type of the court. And again, simple things like turn off your mobile, don't eat whilst you're presenting, and have good pace, have good volume, and on all of the good stuff that Perry and Tadvik have also mentioned. So thank you, ladies, I really do appreciate that. And we'll now move on to the next question, which I have for you is about leveraging legal research and analysis. So, what tips, Tatbik, can you please give to the listeners with regards to this particular topic? And then I'll move on to Perry after that. Thank you very much.
Well, I think thorough legal research and analysis are foundational pillars in the process of formulating arguments, especially in a high-stake competition like the Vis Moot. And first and foremost, they should understand the law. Like legal research will allow them to delve into statutes, regulations, case law, and this understanding is essential for crafting persuasive arguments that are grounded in legal principles and precedents. Another thing is like identifying relevant authorities. Through legal research, they can identify and analyze relevant authorities that support their arguments. This may include landmark cases, treaties, international conventions, and scholarly articles. By citing authoritative sources, they strengthen the credibility and persuasiveness of their arguments. So, in addition to substantive legal issues, also encompasses procedural consideration, such as jurisdictional requirements, rules of evidence, and standards of proof. By conducting thorough research on procedural matters, they can ensure compliance with the applicable rules and maximize their chances of success in the moot court competition. Although these kind of citations during the sessions shouldn't be exceeded, they should be relevant whenever they are citing convention or article or some clauses. They should be relevant, not exceed, because sometimes all the time we can see that in some cases like students bring a lot of example citations, and they lose here time management, and they do not manage to render what they want to say.
That amazing tips there. I really do appreciate that, Chadwick. I've listened and I've learned myself today. Thank you so much for that. And if I can ask Perry for you to now just discuss the importance of thorough legal research and analysis in formulating a good argument with regards to
Sure.
leveraging legal research
I
and analysis.
think, yeah, and first and foremost, take time to understand the case, each aspect of the case, and identify the key arguments and counter arguments under each issue. So for
Yes,
that, you should conduct extensive legal research to find relevant case law, legal doctrine that support your argumentation. So fortunately, many reputable legal databases and libraries offer access for Vis Moot participants. So take that opportunity to enhance your legal research. And when you find precedents, analyze them carefully and use them to build a strong case and understand how previous cases have been decided, how they apply to the current Vis Moot case, and assess both your own arguments and those of your opponents objectively, and identify the strengths and weaknesses of each argument, and develop strategies to capitalize on your strengths while addressing weaknesses also. And anticipate potential counter arguments, as I said, that may be raised by the opposing team and also the arbitrators, and prepare responses in advance. Don't do it at that moment. Prepare in your mind in advance based on your thorough legal research, and be ready to defend your position effectively.
absolutely. And bravo. I agree with everything you said. Thank you so much. And again, it's very important that you do build strong legal foundations for your arguments, and as well as all the materials and the sites and the tools that my speakers have mentioned. You may also be able to access some sort of AI tools now, because technology is advancing and progressing. So that will be quite interesting to see how this area develops. Okay, ladies, we'll now move on to the next question, which is quite a very important question for students, particularly new young practitioners that may have come into the field. So, how would you? I'll start with Perry this time. How would you suggest that speakers or students overcome nervousness, and how they should build confidence when presenting?
Yeah, overcoming nervousness can be challenging. So I think you can consider the following advice. As Tatavik said, preparation is key. So the more prepared you are, the more confident you will feel during the presentation. For that, practice regularly. So practice in front of a mirror, to friends, family, or colleagues, or mock oral advocacy sessions, friendly matches, pre-moots. And repeated practice will really help you become more comfortable and confident in the delivery of your speech. And one thing, I think you should visualize success. So, you should visualize that you're successful. You should imagine yourself speaking confidently, articulately, and this can really help alleviate
I love
anxiety.
that. I love
Yeah,
that.
boost
Thank you.
confidence. And I think we should remember that arbitrators are not the enemies of students. They are typically enthusiastic professionals who share the passion for the Vis Moot as well as for Vienna, that they are eager to assist the students in their growth by providing feedback and sharing their own experience. Therefore, just enjoy the process with enthusiasm rather than giving in to nervousness.
Thank you so much, Perry. And I'll ask the same question to Ted Big with regards to discovering practical tips and strategies for overcoming nervousness and building confidence in oral advocacy.
Well, in addition to Perry's comments, I would suggest like more physical like techniques to practice deep breathing exercise and
Yes,
relaxation techniques to
so
calm your
important,
nerves before
very
entering
important.
that mood courtroom. Like physical preparation, paying attention to your physical well-being is very, very important, like getting adequate sleep, because we know that adequate sleep is very, very important to speak without any with confidence. And another thing is to do warm-up exercises, engage in a warm-up exercise and physical stretches to loosen up your body and prepare for an oral advocacy. And actually experience and exposure is very, very important. Gaining like confidence through exposure to public speaking, advocacy, as Perry already mentioned, and participate in moot court sessions with friends, with every chance that you have, you can use in order to just practice your public speaking.
Amazing. Great golden nuggets from you there. I thank you so much, Tadvig. And yes, as rightly you said, the students are in the participants are in a high pressurized situation, and they may fear anxiety. And all of those tips are so important, because as well as being anxious on the day, they can have fear of making mistakes, because it's unpredictable. Due to the nature of the trial, you don't know what you may be asked, or what may come up from the other side. And so at the end of the day, it's try not to let that impact your ability to think clearly, or to communicate, or to perform. And again, use the strategies that have been mentioned, because that will help you to prepare. Please do focus on practicing, because practice is what makes perfect. And focus on the present, what's happening right now. And as the other side is speaking, the opponent speaking, or the judge is speaking, take notes and manage your time effectively. And again, deep breathing exercises, all of these are such important nuggets, golden nuggets shared by Tadvik there. And again, as Perry rightly said, maintain eye contact. And as well as all that, do take breaks if you need to. Take your breaks as and when they arise, and refresh yourself. You may need a change of seat, so you can just leave the premises, take some fresh air for a couple of minutes, and come back. And that can always help. Some good oxygen into the bloodstream can really work wonders. So again, thank you, ladies. I appreciate that. We'll move on to the next question, which is with regards to the role of team collaboration. And Perry did mention that right at the beginning, but so we'll start with Perry. If you can just expand on the importance of the role of team collaboration for me, please.
Thank you. So I think, firstly, division of responsibilities among team members is important based on their individual strengths and interests. So assigning specific roles, such as researchers, writers, speakers, will ensure effective use of team resources. I think, and I know that many teams mainly do so, they establish regular communication channels within the team to facilitate communication, information sharing, updates, as well as brainstorming sessions, both in person and virtually, actually, to discuss case strategies, share research finding, and address any challenges that the team may face. As I said, like within the team, try to be creative and innovative and welcome input from all team members. Remember that as a team, you have the common goal of achieving success in the moot court competition, and do not forget to celebrate the collective achievements reached by the team throughout the preparation process and beyond.
Amazing. Thank you so much, Perry. I appreciate all of your feedback. And Tadvik, if I can ask you the same question with regards to exploring the significance of teamwork and collaboration in preparing for a moot court competition.
Yeah, thank you very much. Actually, collaboration allows team members to provide constructive feedback and peer review on each other's team. As Perry mentioned, like having a network is very, very important, and sharing all information within the arbitrators, coaches, and teams. So, and also by soliciting input from teammate, students can identify blind spots, refine their argument, and improve the overall quality of their submissions and oral presentation. Accountability and motivation is very important here, like working as a part of a team fosters a sense of accountability and mutual support. Knowing that they are part of a collective effort motivates students to stay focused, meet deadlines, and strive for excellence in their individual contributions. And sometimes during the sessions, we feel like how the students are collaborative and connected with each other, because whenever one of the arbitrators is asking like question, the other is helping his or her friend in order to find a specific place in order to provide the evidence, and thus this is very, very important. So teamwork and collaborations are integral part to the success of moot court teams for preparing for the Vis moot court, and students can harness the collective intelligence, creativity, resilience through their professional developments.
Great. I absolutely loved the part about having an accountability partner. I think that is so important because
Yeah.
it just ensures effective engagement, and you understand the importance of teamwork through collaborating, and then you can assign roles effectively, and you establish effective communication within the team. And so, all of these golden nuggets that have been shared with you are very, very important. So please do take notes and follow the suggested techniques that have been given by our professionals today. Thank you again, both of you. So the final question of the day that I have for you is with regards to feedback and improvement. So at the end of the session, when the judges will give the feedback, students can be extremely nervous, but it's a great opportunity for them to learn and grow and understand the value of the constructive feedback. And this should be, the more competitions they enter, the more continuous the improvement will be in having these advocacy skills. So if we can start again with you, Tadvik, and if you can just expand on this and give me your tips on how students should handle feedback and improvement.
Yeah, generally, like from my huge experience in Vis moot courts and also previous, whenever we are giving students feedback, they are just very, very comfortable, and they are accepting these feedbacks eagerly. Like no tension, no stress, none of these exist. Well, understanding the value of constructive feedback and embracing a mindset of continuous improvement is essential here, because actually Vis moot is for practicing and being coached, being like having the possibility to learn. Constructive feedback offers an outside perspective on advocacy performance, like providing valuable insights that may not be apparent to them. And by soliciting feedback from coaches like peers and judges, they can gain a deeper understanding of their strengths, weaknesses, and areas for improvement. And also, like focus here important. Constructive feedback enables students to prioritize areas that will have the greatest impact on advocacy skills by targeting specific aspects of their performance identified through feedback. They can focus their efforts on areas where improvement is most needed.
Amazing, thank you. And Perry, if you'd like to expand on that too, I'd be grateful.
Thank you, Sabina. Just view feedback as a valuable opportunity for development. Listen attentively to feedback provided by your coaches, peers, or arbitrators, and approach it with an open mind and willingness to learn. Try to participate in numerous pre-moots and friendly matches, both online and offline, seeking feedback from different professionals, because each perspective can offer valuable suggestions for improvement, helping you gain an understanding of your strengths and areas for development. And you should also pay attention to specific aspects of your advocacy skills highlighted in the feedback, such as legal analysis, oral presentation, or rebuttal techniques. And take time to reflect on the feedback you receive and consider how it aligns with your performance goals. You can experiment with different techniques to see what works better during your preparations. And please understand that improvement takes time, and challenges are a natural part of the learning process. So stay persistent and committed to your goals and growth journey, even in the face of obstacles.
I love those positive words. Thank you so much, Perry. And with that, the session does come to an end. So just to conclude, before we leave, that this session has been about exploring the art of persuasion and unraveling the intricacies of oral advocacy in the Vis Willem C International Commercial Arbitration Moot Court. William Cornelis Vis was a professor, and he was a world recognized international commercial disputes expert. And this international competition is potentially hosted in his name, and is held annually in Vienna, in Austria, and it's considered one of the largest mooting competitions in the world. So it's a great opportunity for you to practice, prepare, and receive the feedback and improve. The experience of taking part in the competition is actually very, very invaluable, and you can reach out to within your jurisdiction. You can reach out to barristers or solicitors or lawyers to help possibly mentor you and improve your ability to construct legal arguments and form clear and persuasive arguments in a legal sort of professional way. And there may be workshops available where you are, and the competition in itself will help the challenges that you face, or to overcome those. And it's a good way for you to start critically thinking, and it's an opportunity for you to meet very talented individuals that have very similar interests or same interests as you. And it's exploring how international courts and arbitrators provide practical tips for resolving international business disputes, which is usually the business community's preferred method of resolving these disputes. Now, this today has been our very first session, and we do intend to have further sessions in the future. So please do keep your eyes open for any invites that come up. And again, the golden nuggets that have been shared by my speakers today are invaluable because they're based upon real life experiences, and they host these sessions regularly. So you've got some great feedback from very highly professional ladies here. And as I say, do keep an eye out for further invitations in the future. And if you would like to reach out, please don't hesitate to send us a message on our LinkedIn chats. Again, thank you very much to you both for coming this evening and participating. And we look forward to speaking with you both very soon. Thank you very much.
Thank you very
With
much.
that, I'll end the meeting.